What is up, everybody? Jay Costa here from New Jersey, living behind enemy lines. I wanted to get this video out quick to you because just yesterday was the big day, February 11th, 2026, where the full Third Circuit went en banc on Koons and Siegel versus Platkin, which is the massive challenge to New Jersey's sensitive places bans and that infamous vampire rule. Now, unfortunately, I was unable to attend as I was on daddy duty, but I just listened to this full recording, link in the description, by the way. I pulled the key moments from it, and now the reactions are pouring in, and guys, we are looking pretty good. So let's break it all down, what the judges asked, how the lawyers responded, and what both sides are saying and feeling right now. Now, first, a little bit of background. After the Bruin decision, New Jersey passed one of the most aggressive carry restrictions in the country, including over 25 quote-unquote sensitive places where law-abiding permit holders can't carry, like you and me, we can't carry, in parks, beaches, libraries, bars, zoos, youth sporting events, you name it, and basically includes every single private business open to the public unless the owner specifically posts a sign allowing guns. Now, that's the vampire rule. Carry is banned by default. If that's not an infringement on our Second Amendment rights, I don't know what is. Now, we have been sitting on a mixed ruling on this until the whole Third Circuit took it en banc, and yesterday was the showdown, and the plaintiff's attorneys, aka the good guys, may have gotten the best of the state, leaving us all praying for a positive outcome. Now, the oral arguments went for just over an hour, which I did upload the full video to on an unlisted video on my channel. Like I said, link in the description box down below. We don't know where the decision is going to end up, but according to our friend John Petrolino, who was there, if you're counting points on punches landed, Liberty will ring, my friends. Now, speaking of John, in this case, we will be discussing this case at length on our next podcast. We will be recording it this time next week, I believe, and it should be out within a few days after that. If you have not checked out my new podcast, The Behind Enemy Line Show, where we talk about everything New Jersey Second Amendment related, definitely check it out. Hit the subscribe button and that notification bell. You could also find it on YouTube here, of course, as well as Apple Podcasts and Spotify. Now, attorneys Peter Patterson and Aaron Murphy argued for the Koons and Siegel plaintiffs respectfully, and Angela Kai spoke on behalf of the state of New Jersey and defended the state of New Jersey, and the state of New Jersey was up first for their own argument. Now, the state tried to defend their huge list of sensitive places as modern locations to history. Mrs. Kai pushed post-Civil War laws passed by the Democratic decisions of the legislature at the time, and said the increased public carry in the 1850s created a new social problem that justifies broad bans today somehow. I don't know how she got there, but the judges did keep dragging Mrs. Kai back to 1791, the founding era, which Bruin does, of course, emphasize. Now, one exchange did stand out to me when the state was asked if past legislatures faced similar problems and chose not to ban carry. Doesn't that hurt your case? The judges simply were not buying the state's attempt to lean on post-Civil War laws. One judge literally read from the Bruin opinion, reminding them, the state, that founding era evidence controls all based on Bruin. Now, the state basically told the judge, don't overread what the Supreme Court said in Bruin. Okay. They also got absolutely hammered on the so-called vampire rule. One of the most ridiculous moments came when a judge straight up asked the state, what places can't you designate as sensitive? I mean, this is like I was up there asking these questions. It's amazing. But anyway, New Jersey's answer, bakeries and small shops. But wait, those are already banned under their own vampire rule unless the owner posts a sign saying yes. They basically made every public place off limits, which is, of course, the whole point of this and the whole reason why all those people were sitting and arguing in court yesterday. Now, the state also frequently used the examples of both schools and playgrounds. That's no surprise. They use those because they seem scary, yet the plaintiffs were not even challenging restrictions on school property, which shows you how soft the state's arguments actually were and how much they're reaching on some of these things. The state did cite old school rules, like rules set by the actual school, but judges noted those restrictions mostly targeted students not carrying instead of armed adults, and were rules by the school and not set by the government. The state really struggled to tie everything together here, in my view. Now, J Factor, some of you may know him on X, made a great argument on his post, pointing out that the state's clear hypocrisy on this is unimaginable. He said, interesting that up until Bruin and the Danielson's Bruin response bill, the statute 2C 58-4A read, any person who holds a valid permit to carry a handgun issued pursuant to this section shall be authorized to carry a handgun in all parts of the state. Not this nation's historical tradition of firearms regulation nonsense. So while the state is now arguing that all of these restrictions have full legal and historical backing, before Bruin, there were actually no restrictions on where to carry. But that was when only politicians and judges could get a permit to carry in New Jersey, not you or I. Rules for thee, as they say. After the state, it was the plaintiff's turn for their arguments, first starting with Erin Murphy for the Siegel plaintiffs. She argued that New Jersey's overall scheme defies the Bruin decision and the standard set by it, with extremely subjective good character checks, the forced insurance that they tried to put on us, the high fees, plus these obvious location bans in the sensitive places. She pointed out that the plaintiffs are only challenging about half the list and concede that obvious ones, like courthouses, are okay. This is very smart in my view, because courthouses are already protected by armed security, and it makes the plaintiffs, of course, seem reasonable to the court. Now, Mrs. Murphy stressed that outright bans were very, very rare historically. States usually just regulated concealed carry while allowing open carry. Murphy then made her best point of the day when asked by the judge why it's unreasonable to ban guns in lots of places. Quote, when guns today can be used to kill lots of people, Murphy said by that standard, there is no limiting principle. You can ban carry everywhere, even slightly crowded. Now, Pete Patterson was next for the Koons plaintiffs, and he brought the strongest arguments based on what I'm hearing, that security is the real historical principle to apply here. You see, at the founding in 1791, when the Constitution was signed, restricted places usually had actual security. In unsecured spots, carry was sometimes required in a place like a church. With something like polling places, the old dangers don't really exist anymore because that was a pre-secret ballot. So the threat of voter intimidation is down to next to nothing today. Plus, many modern polling locations have minimal to zero protection. Mr. Patterson gave us a key line in the hearing saying, quote, if criminals can walk in armed because there's no security, law-abiding citizens have the right to defend themselves there. Boom. Now, from what I can tell on the audio, there's no video, so maybe it was different in person, but from what I'm getting from everyone that was there, they're agreeing with me. The tone of the judges overall here seemed very favorable to us in the plaintiff's positions, and seemed, to my untrained ears, they seem like at the very least, skeptical of New Jersey's extremely broad approach, restricting where we can and cannot carry firearms. In fact, during rebuttal, a judge asked for founding era analogs, and New Jersey basically had nothing. He asked, quote, you have one New Orleans law from 1817. Do you have anything closer to founding? New Jersey said flat out, no. The reactions started flying right in after the hearing ended. New Jersey Acting Attorney General Jennifer Davenport posted this on X, quote, guns have no places in schools, playgrounds, bars, and concert venues. That's common sense, and it's what we told the Third Circuit today in defending one of New Jersey's key public safety laws. Keeping New Jersey safe from gun violence is a non-negotiable for me. I mean, that is so classic, framing it as simple safety while ignoring the enshrined right to self-defense that we are all born with. Now, on the Second Amendment side, reactions were also coming in very, very quickly. And of course, they were much more optimistic. Kostas Moros, I hope I'm saying that right, from the Second Amendment Foundation, who live tweeted the entire thing, and I appreciate tremendously. He posted on X that, quote, we're going to win, mostly. I doubt we'll bat 1,000, but the most obnoxious, sensitive places are likely going to be knocked out. New Jersey has no limiting principles to their broad claim characteristics of sensitive places. There was another post as well that basically said, you are going to lose big time. And I am not a lawyer, but that's kind of how I'm feeling right now. Gun control advocates, on the other hand, have been quieter so far and sometimes mute. Our friend, the aforementioned John Petrolino, who was there, like I said, asked several women wearing red Moms Demand Action shirts to comment on the arguments. They all declined to discuss the arguments, stating that they're not able to comment without their spokesperson. And the rest of them have been mostly echoing the Attorney General's common sense BS, but the divide is pretty clear. The state is defending total unconstitutional control of our self-defense, while Second Amendment rights advocates are highlighting history, security, and the lack of any real evidence, substantive evidence from the state. Now, what can we expect going forward? Well, the decision probably won't happen for a while. These en banc cases take time. We're talking anywhere from 3 to 9 months, let's say, and it's not likely that an opinion will come prior to the U.S. Supreme Court publishes their opinion on the Wolford case out of Hawaii, but things do seem to be leaning towards our side pretty strongly at this point. Based on the argument and early reactions, many of us, including myself, are cautiously optimistic that the court will strike down a lot of these sensitive places bans. And frankly, even a solid partial win for us would be massive for New Jersey gun owners across our state and set a strong precedent elsewhere. The loser is almost certainly going to try to bring it to the Supreme Court, where I would also like our chances yet again. Now, yesterday's hearing exposed how extreme New Jersey's law really is, inflicting and infringing on our Second Amendment rights and our natural right to self-defense. The Attorney General wants to keep calling it common sense, yet they clearly lack any such attribute, because the Second Amendment is not a law per se, right? It's a right that's not directly tied to firearms either. It's rather our natural right to self-defense. I say this in almost every video. Do you and I have a right to defend ourselves from harm? Yes or no? Yes or no question, it's that simple. And as Mr. Patterson argued, if a specific location is not protected by security, we must have that right intact to protect ourselves, our family, and our country. Now, that is it for today, guys. Thank you so much for watching. What do you guys think? Did the plaintiffs land the bigger blows here? What do you think about the questions from the bench? What do you think our chances are that we're going to come out with a W here and be able to carry without having to disarm ourselves in a parking lot 4 times a day? Let me know in that comment section down below. And also, if you want more Second Amendment updates like this behind enemy lines, hit the like button, subscribe, hit that notification bell, and follow me as well. And on Instagram and on X, @JCosta USA. Guys, stay safe, stay armed, and keep fighting. God bless.